Chief and Grand Rising to the sovereign, original, indigenous, natural, divine heirs. Today is November the 7th, 1442 on the ancient moon calendar, 1441 on the ancient sun calendar, and 2021 on the civilian or Greco-Roman calendar. All rise and stand. This is a sovereign, original, indigenous, natural, divine, ancient Al-Moroccan, Moorish American Article 3 court action. I am Sovereign Living Justice, Pauline Denise Ritchie, in capitis diminutio, in red ink, in propria persona sui juris, in proprio solo, and in proprio heredes. My free chosen sovereign appellation is Light Fiduciarie Bay, in capitis diminutio, in red ink, in propria persona sui juris, in proprio solo, and in proprio heredes. We are the original indigenous, sovereign, ancient Al-Moroccan, Moorish American ascendants of the great pharaohs of Kemet and of the ancient Moabites and Canaanites. Our full faith, trust, allegiance, credit, and energy is hereby vested in ourselves, for we are the people who are the de jure, original indigenous, natural divine, Moorish National Republic federal government, and the sovereign ancient empire state of Morocco. We hereby exercise all sovereign rights at this time and at all points in time, non pro tunc. So on starting tomorrow, the calls that we normally have 3 times a week, we're not going to be having them for the next 2 weeks up until Wednesday the 24th. And on Wednesday the 24th, we will resume the calls. But for the first time in 4 years, we're going to take 2 weeks off from the calls, and we'll still be working and still be doing the things that we do. We have some specific demonstrations that we are wanting to go ahead and bring out into full fruition. So we are going to be focusing on those during this time period. So again, from tomorrow, which is November 8th, until the 23rd of November, which is a Tuesday, we will not be having these calls on this platform. There are other calls that will be going on other platforms within our government, so we're comfortable in taking the time to focus in on the demonstrations that we have coming up. And with that being said, let's go into what we were going to discuss today. So we want to first talk about the Magistrate's Guide to the Vienna Convention on Consular Notification. And this document is it's a great opener to assist us in preparing to fully take on the responsibility of governing the land with regard to any foreigners who are on our land. That's what this document is about. We can take this document and look at it from 2 different perspectives. From one perspective, we can look at it as us needing some guidance on what happens if Moors are taken. Okay, we can look at it from that perspective. Today, we're going to be looking at it from a mixed perspective, but mostly of us governing and our courts governing the foreigners that are on this land, because we actually need to be changing our perspective on what's going on the land, because those fake courts can't last. They're already finished. They're now preparing to have the Article 3 courts fully operational, which in some territories, the Article 3 courts are fully operational already, and in other territories, they're still working their way through. But I think for the most part, all the territories have at least one Article 3 court that's already operating by the Moors. What does that look like? It's Moors who've been doing court action in the territory. And all of our territories have Moors who've been doing court actions in them. So this guide is going to be for us because where we're going from this point is in each of the territories, and again, we're preparing for all of this in our territory. In each of the territories, we Moors are actually going to have to start connecting with others who are in our territory, for example, the Olmec Moors. I think everybody has Olmec Moors in their territory. Well, we need to be connecting with them and saying, hey, you all need to get your consulates up and running so that when things happen with your with those who are who identify as Olmec Moors, because you know we're all one, we know that. But there are some who identify as Olmec Moors and they have specific lawful needs, and so we're going to be saying, okay, we're up and running, and we need to go ahead and get all of the other consulates for wherever Moors come from. So we're talking the indigenous people, okay? And so the Moors from Eritrea, the Moors from Nigeria, Ethiopia, they all need to be getting into the mindset of, okay, we need to get our courts and our consulates up and running so that we don't have to keep going to the foreigners who are not, this is not even their land. So they will need to be getting in alignment with what's going on with us. And I want to show you something in the supremacy clause that actually in the Constitution, it states that the Constitution is for all land. We just have to know how to read that when we see it. We have been programmed to think that the Constitution is just for here, but it's not. And it's right there in plain writing in the Constitution. I want to point to the supremacy clause there, and I'll put it on the screen. Article 6. The second paragraph of Article 6 states that this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or the laws of any state to the contrary notwithstanding. Now, we know that this particular version of Article 6 is capitalized and hypothecated. But when we take this and put it in red and put it in all lowercase letters, what it's saying here is that all treaties under the authority of the United States, and we know that the United States is not, so the ones who've been pretending to be the United States are actually a corporation. That is not the United States. Okay, that's a corporation. They don't govern anything. The United States in reality is the United States being the Moors in red and all lowercase letters. They even have the United States of Africa and the United States of Mexico and the United States of other lands also in red and all lowercase letters. Okay, so it's not a corporation. It doesn't consist of foreigners. It consists of the actual states that are on the land of indigenous Moors. Okay, that's the United States in red and all lowercase letters. So it states there that it shall be the supreme law of the land. There's land over there in East Africa. There's land at Antarctica and the Arctic. There's land at Europe, and we're again talking about the land. This Constitution is the law, the supreme law for all land, not just this land, because all lands are under our authority. Okay, so United States, when we talk about United States, is all Moors. It's in red and all lowercase letters, all Moors, and it does not include any corpses and corporations. Okay, so right there, it's saying that's the Constitution and all are under the authority of the United States. It doesn't say a corporation. It doesn't say foreigners. It doesn't say any of that. It says United States. And when we put it in red and all lowercase letters, it is the supreme. And we know that we are the supreme law for the land. We know that. And we know that all lands are under our authority, all of them. And there it is right there in Article 6. Also, it says it shall be the supreme law of the land, period. It doesn't say land here or land there. It says land. So anywhere that there's land, that land is under the supreme law, which is the Moors. So in going back to this document, here, we want to take a look at this Magistrate's Guide to the Vienna Convention on Consular Notifications. Now, this is an abbreviated document. Again, it's about notification. It's not about actual Vienna Convention actions, which are court actions, by the way. So on this document, the way that we're looking at this document today is it's a peek into the future on our land and how we're going to do things, but it's also a way that we can look back at what's been going on with us and, you know, those who were unlawfully occupying our land, and we can see where certain things were happening and we can point those things out, okay? I want to take you to first to the section in this document where it says a summary of requirements pertaining to foreign nationals. Okay, a summary of requirements pertaining to foreign nationals. It says here, when foreign nationals are arrested or detained, they must be advised of the right to have their consular officials notified. And again, we're looking at this from the point of us governing our own land, because we're going to be doing this when it comes to other nationals on our land who are from other places. So there'll be Nigerian nationals, there'll be Olmec nationals, there'll be nationals from other places, and we will be, our consulate, and this is why we have consulates on our land. This is why we have consulates. We have consulates so that we govern our land with regard to any other foreign nationals. Okay, that's why we have consulates everywhere on earth. It's because all land belongs to us, but we do have those that are foreign, considered foreign nationals on our land. Okay, so these who come here, as we're starting to look forth into the future a little ways, and it's not very, very far from now, when foreign nationals are arrested or detained, they must be advised of their right to have consular officials notified. Who are the consular officials? The consular officials are whatever they say their nationality is going to be, and again, what we're doing now is also pointing out places where we can be proactive in our own, on our own land, so that we don't have to go through certain things on the land. That's what looking at this is about too. So consular officials, as we gather together on the land, is going to be the Olmec consulate and the Nigerian consulate and the, you know, wherever the Moors are from. Okay, they're going to be, they will have consulates in all of the territories who can be called in the event that there is some issue that comes up, some conflict on the land, okay? In some cases, the nearest consular officials must be notified of the arrest or detention of a foreign national regardless of the national's wishes. And again, we're talking about anyone coming here to this land, and I'm pointing that out for a reason, okay? And we'll go into that in just a little while. Consular officials are entitled to access to their nationals in detention and are entitled to provide consular assistance. When a government official becomes aware of the death of a foreign national, consular officials must be notified. Let me go back to number 3. With regard to number 3, we needed to see and know on our own land that we don't go in to see other Moors in a capacity that says that that Moor is on someone else's land. That's not where we go in to see Moors. That's not the position that we take when we're going in to see Moors. When we're going in to see Moors who've been detained, they're on their own land still. And that is the position and the perspective that the United States Corporation Company has been taking. They've been taking the position that whenever someone's arrested, that they're in the quote-unquote United States. Well, the United States only existed on paper, and it doesn't even exist there except as a debtor to the Moors. So now we're changing our perspective altogether, and we're looking at this the way we should look at it, which is Moors are on their own land. Where's the conflict? What's going on with this conflict here? Okay. When a government official becomes aware of the death of a foreign national, consular officials must be notified. So we'll be notifying these other consulates and consular officials on our land of something happening with one of their foreign nationals. And then number 5 says, when a guardianship or trusteeship is being considered with respect to a foreign national who is a minor or incompetent, consular officials must be notified. This is very important. This is why it's so important to be competent when something, as we move forth in what we're doing. Everyone is looking at how we're growing and how we're exercising and using the information that we have. It's not enough to say that you're of the bloodline and birthright. We must be competent. We must be. Or else they tend to try and shove you into a trusteeship or guardianship that says ward of the state, ward of the state, ward of the state. Okay? And we cannot, it's time out for that. Competence or a minor. A minor is and we're going to point out in here where it shows what that looks like. A minor is someone who is, you can be 75 years old and be a minor by what you say and what's in your documents that you put out there and how you contract. That determines whether you're a minor or incompetent or whether you're competent and a full majority. Okay? So that determination is being made on a daily basis. Okay? Anytime things happen with Moors or with anyone on the land, there is a determination being made by those who are not even competent to make that determination as to whether someone is a minor or incompetent. Okay? So it says these are mutual obligations that also pertain to American citizens abroad, et cetera, et cetera. Now, again, this document is written from a citizen perspective. And this is really them saying when the Moors wake up, they will fix the language in here to fit what needs to be stated with regard to them. But they could not state for us how this process is to go for us in proper language. So they have to state it in the language of citizens and minors and subjects. Okay? So I want to, in the interest of proactivity, because that's really what we're doing now, is being proactive about everything that has to do with us, so that we can continue to stay in our rightful place as we begin to govern the land, and then also any foreigners who come here, because that's where we are now. So it says here, steps to follow when an individual believed to be a foreign national is arrested or detained. Now, this is what they've been doing, determining citizenship. Okay, for us, we can just change that to nationality. Determining nationality. It says right here, and this is in the interest of proactivity where we are concerned, all determinations of citizenship must be on the record. If no record is made, record in the docket all information establishing citizenship, including the responses of detainee, advisement of rights, and other actions taken. So how do we get out ahead of all of this arrest and detainment that's going on with the Moors? We put competent documents on the public record. What do competent documents look like? They are in red and all lowercase letters when it comes to the Moors. They're on government letterhead, in red and all lowercase letters. That is competent documentation. Yes, we talked about the monochrome ink, but your foundational documents must be in red and all lowercase letters. That is competent recording of your own documents, so that even before any of this happens, your nationality is already determined by you. Because if they're seeing documents and the documents are not competent, they're saying we have to make a determination on the citizenship, quote unquote, of whoever this is. Okay. So nationality is the order of the day for the Moors. And then as we begin to operate our Article 3 courts where foreigners are concerned and where things are happening on our land, then we are to determine, if there's nothing on the record, we have to determine the status of whoever it is that's standing before us, or whoever it is. Because see, now that we have proclaimed competently statehood, and I'm putting heavy emphasis on the word competently, declared statehood, and I'm just saying where we're concerned, we now have to start looking at governing the land from this perspective. So what was one of the things that we said happens when we're doing court action? Asking questions. And look at what they're saying to do here. Ask questions, and there's going to be a total of 3 of them. Place of birth, where the detainee was born out of the United States, or whether the detainee has been naturalized under the Constitution and the laws of the United States. So when we're looking at these processes in terms of ourselves first, let's look at it from our perspective. We already know that, again, competent documents on the public record, and the competent documents include a sovereign living birth affidavit. We talked about that in the past. We have a list of documents that we can put here on the screen, and we'll just name off the first 5 or 6 competent documents that need to be on the public record. Those documents being name change or appellation change in judicial proclamation, a lien on the the Social Security number in dead ink, and on the wardship and nom de guerre names, a lien on those. A termination of all corporate contracts, and we're going to show in these documents that they've been looking at those things the whole time. Okay? A termination of all corporate contracts with the United States Corporation Company. We have no contracts with them. Okay? Those things in black ink and capital letters are corpses. We don't have any contracts with them. And again, whenever we're saying that we're Moors and something's going on and the occupation was looking at us saying what we were saying, they were making determinations based on what came out of our mouths. And if we were not doing court actions coming out of our mouths, then usually they would determine, quote unquote, that either we were minors or incompetent or citizens or U.S. citizens based on what was said. So it's time out for that. We must be competent, and court actions are the way to do that. Court actions, anytime we are speaking to anyone who is not of the bloodline and birthright, we need to be speaking to them as the court. I don't care if it's at the grocery store or on the side of the road. A court action needs to be done. On the phone, court action needs to be done before we speak, so that, again, competent identification of the parties is made. And that way, anything going on with us, we will already know that we have support for everything that takes place. We have support. When I say we have support, if something happens where we've done a court action and we put the Constitution in place, because that's what we're doing when we do the court actions, is we're saying, okay, status has been established, therefore you are now under the Constitution if they're a subject. And that's really where we are right now, is making sure that the subjects know where they are and where they stand on the land, according to the Expatriation and Citizenship Act of 1954. And there was also one in 1906 that states moorishe subjects ipso jure. If foreign nationality cannot be determined, okay? If it can't be determined, then moorishe subjects ipso jure. So that's how we're looking at this from that perspective. And we can look back at what has happened with us previously and know that everything is now from the perspective of us governing. Okay? And the things that we've been through will help us be better government on the land. Okay? Because when you look at this document right here, where it says it's talking about these different steps to follow, they're really basically just determining, okay, who is this that we have here? Identities and status is being established here. Okay? And they're saying, you know, if certain things happen, then the detainee is a foreign national. If not, then they're not a foreign national. And then what do they tell them? What do they say they're doing? Entering in the record or making docket entry of finding of citizenship. So they're basically on a fact-finding mission. Okay? Well, our job is to make that fact-finding mission unnecessary completely. That way we can do this from the right perspective. We can look at this from the right perspective. How do we make this fact-finding unnecessary? Competent documents on the public record. And then they start asking questions because they want to hear if what you're saying is matching the document. Really, they're just doing a court action when they ask the questions. They're taking jurisdiction, depending on the answer. And if the answer is a higher court is speaking, then they will know they don't have jurisdiction, period. And then they're determining here, because there are some quote-unquote countries that have mandatory notification that if one of their nationals is detained or arrested, then there's, based on treaties and agreements, international agreements, there has to be notification is either mandatory or in some cases it's not mandatory. So again, as we continue to govern, we're going to be looking at what agreements we have on the public record and is it mandatory for them to be notified. Now, we are going to know all of this before we are even placed in this position, because we will have established, like we were saying a little while ago, we're going to be meeting with the Olmec Moors and the Nigerian Moors and the Swedish Moors and the Russian Moors and the whomever, asking them if they have consulate services here for themselves and for those who are with them. We actually have to, that is our job, that is one of our responsibilities in governing the land, is making sure that everyone has proper presentation or representation. And Moors are not represented by anyone. We're not here on this land. Okay, the primogenitors, no one represents us. We present ourselves. And then those who are on our land to do commerce, okay, then we have to establish relations, consular relations with them. So we're not foreign, okay. I think that's been a sticking point as to, for some who were thinking that we should not have consulates on our own land. We are the only exception to that rule on the earth because all land belongs to us, okay. So here, it says, notification is mandatory on the left-hand side, and on the right, notification is not mandatory. So then they go through a series of things of informing and finding out other things, like if you will notice, right here it says notify consular officials of country of citizenship without delay of the arrest, detention, regardless of foreign nationals' wishes. Why? How is it that they can go over and above a foreign national's wishes? We know that they cannot go above and beyond ours because, again, the land belongs to the Moors. And we are looking at it from our true natural order, which is we are the supreme law for the land. But we can go over a foreign national's wishes and notify depending on the agreement that our state, the Empire State of Morocco, has with their state. International law always supersedes laws made by the states, okay, the several states. And again, that is Article 6, back to the Supremacy Clause, all laws made by the states to the contrary of the Constitution, this Constitution and its treaties is notwithstanding. So those states cannot go, if we have consular relations with them or some consular agreement, then the foreign nationals can say, well, no, don't call them. I have an attorney. Well, attorneys are not a thing on our land. That they don't practice on our land like that. So, and we have an agreement with, it's an international agreement with your state. So then we have to notify your state regardless of what you say. In other words, we're not going to contract with you outside of international law. Because, see, that's what's been going on with us in the past. is we were contracting with the United States Corporation Company because there was no consulate to call. There was no, they would always slap an attorney there. Well, this is that in reverse, except it's according to the law. Okay, foreign nationals on our land have to be, they do have a say in what goes on with them. Absolutely they do. However, if our state, our empire state, has made an agreement with their empire state, with their state, rather, or their nation, then we have to honor that above the ability to contract with an individual. Okay, because there's a certain element of individual sovereignty that foreign nationals do not have, that we do have. And we've proven that over time, even in our fleet, where even though there may have been agreements internationally involved, whenever we spoke, the United States said, we got a contract because they're not doing court actions. They're not the state. They have not declared their statehood. So we have a contract, and I'll tell you that automatically when we were contracting with the United States Corporation Company in that manner, they automatically, by their own codes and statutes, put us in United States Corporation Company status. And we're going to show that in just a minute. So the outcome, again, of this graph here of steps to follow when an individual believed to be a foreign national is arrested or detained, what's the outcome is they did all of that in order to enter in the record or make docket entry of notification. Well, for the Moors, and some do not really, they're not really comfortable with this yet, so we have to get comfortable with it. We Moors, the primogenitors, must put on the public record competent documents that state who we are by court action. And that's why we put the court action language. Why is that? Because that will be us entering in the record proper notification of our sovereign authorities as to our status, because we're our sovereign authorities. We're the only nation on earth that has that caveat put into our bloodline and birthright. We are our own sovereign authority, especially now that we have unified and the state has formed. We've done the things that needed to be done where nation and statehood are concerned that keep us out of the corporate status. We're not connected or attached to any 501c3s, et cetera, et cetera, et cetera. We're not under any corporation. In fact, all we have done is lean corporation after corporation, and they've been doing exactly, getting in alignment with the liens. We see that. You cannot lean them and be a part of them too. And they have to be leaned so that they get in subject status. So now, they have some steps here. It says, number one, it is imperative that the determination of citizenship be on the record. What have we been suggesting? And again, we say suggest, but it's actually the law. And we don't make suggestions that aren't the law, or at least in alignment with the law. It is imperative that the determination of citizenship be on the record. And that's another reason why we are encouraging all Moors to send their documents in red and all lowercase letters to the Library of Congress. That way, there's no one No agent, principal, heir, assigned, or any derivative thereof that can say they don't know who you are. And it's done even with the Library of Congress. That court action language needs to be at the top of those affidavits, because look at what it says here. Courts of record should ensure that the court reporter records all information regarding determination of citizenship, advisement of rights, and actions taken. Well, we don't leave that up to someone else because we're not citizens. We're nationals. So we take that into our own hands and put it on the record by our own courts. We don't let other courts do that for us. They don't have the authority nor the competence to determine anything for us. Now, when we're looking at this as us governing our own land, then the citizens have to have, the subjects need to have something on the record too. And they're aware of that. The subjects need to have something on the public record that says, I'm a Moorish subject ipso jure according to this law right here. Okay? And who are the courts of record? We are. It says courts not of record should record in the docket all information establishing citizenship, including the responses of the defendant, advisement of rights and actions taken. And again, depending on which perspective you're looking at, when you're looking at it from our perspective that we are, because we know we're the government, there is no other. And when I say we, I mean all Moors. We're talking here about nationality. Okay, again, we're not leaving it up to others to do that for us. There's no such thing from our perspective as a court that should be operating that's not a court of record. All courts should be courts of record. And that's how you know this is written by those who are, you know, of the citizen status. Okay. And then it says here, in addition, warning forms should include Vienna Convention warnings in the event that a foreign national is arrested or detained. Now, we're going to skip over, and I'll put the link to this document here. Let me go ahead and put it in the chat so that you can look this up for yourselves. And I will also place it under this video on YouTube at Like the Jurisdictional channel. Okay. Okay, there's the link to the document in the chat. Now, we're going to skip over to another point that I wanted to make here. About this document. Okay. Let's take a look at the mandatory notification countries and jurisdictions that they have here. I found this interesting. I looked at this list that they have here, and I noticed that there are two pretty interesting places that are missing from this list. Morocco is not on here as a mandatory notification country and jurisdiction. Neither is the United States. So I kind of thought about it for a minute and I said, okay, this document comes from Texas Territory. Texas Territory knows that this is Morocco. They know that already. So this is actually, you know, it's, again, we put our own notifications on the public record. No one does that for us, okay? Now, let's take a look. I want to bring your attention to one of the frequently asked questions that they came up with here. Yes, it is the Lone Star State. And they have actually, Texas has implemented the Lone Star strategy. That's what they call it, the Lone Star, it's the Lone Star strategy or the Lone Star convention or something like that. And that just means that they're putting the Constitution back in alignment and putting everything that should be there back in alignment. Okay, they're putting the Republic there back in place, and in reality, the Republic never left. I want to bring your attention to this question right here that says, what about dual nationals? Okay. Yes, Shatali, when we read the Biblios, we understand why we do what we do. Yes, Islam. So here it says, what about dual nationals? The answer they're saying is a person who is a national / citizen of 2 or more countries other than the United States should be treated in accordance with the rules applicable to each of these countries. A person who is a citizen of the United States and another country may be treated exclusively as a U.S. citizen. What are they saying? And what do we say about them and about all of that? That is why we say terminate all corporate contracts with the United States Corporation Company. That is what they have been doing. When we say that we're more, but we have contracts out there that say otherwise. That's what they've been doing. They've been saying, oh, it doesn't matter if the Moors don't know the law, but we're just going to go ahead and treat them as a U.S. corporation company citizen because we see that they have these contracts out here that they've not terminated. They've not leaned the straw that the United States Corporation Company was using to even take people in the first place. They've not done a court action on that straw. The court has not spoken as to the use of that debtor transmitting utility. That's why they're right there in writing. Doesn't matter what you're saying about, they go by what are you doing? If you have contracts with the United States Corporation Company that you've not terminated, and here's the thing, I've seen more terminate contracts on paper, put it on the public record, and 2 weeks later, there they go, writing again, black ink or blue ink, signing another contract. And then something happens and they get detained, and I say, well, you know, let's just go down our checklist to make sure all these things are done so that we will know how to proceed. Did you, you know, you got your name changed and everything on the public record. Did you terminate all corporate contracts? Yeah, I terminated all corporate contracts. Okay, have you signed anything recently? Oh, yeah, I did sign that so-and-so, you know. I needed a new television, and I signed a rent-a-center, you know, and I'm just using that as an example, you know, then you need to re-invoke jurisdiction. And it has everything to do with, and we will prove that in these writings, this is what they've been going by. It has everything to do with what comes out of our mouths too. Because you can terminate all corporate contracts on a public record, you should. That is actually mandatory if you want to get down to what the law says. Because again, they are either we record it or they record it. Okay? That's what this is who's the court of record. And if we don't have it on the public record, silence is acquiescence. Then they just say, okay, we got one that's not documented here. So, you know, terminate those corporate contracts. And then re-invoke, and every now and then, and I do it, and I've stated this before, every now and then I'll make my statement on the public record. I am, you know, all rise and stand and remain standing. I am sovereign living justice, Pauline Denise Ritchie, and capitis diminutio nolo, innheritense, and proprio possessione juris, and proprio solar, and proprio redes. This is an Article 3 ancient Moroccan, Moorish American consular court action. I hereby terminate all presumed corporate contracts. Nunc pro tunc. This sovereign justice stands as law, period. So let me show you also in these same documents here. The question is, why are state and local government officials expected to provide such notification? Because see, if they were if they were actual real states and government, they would have been doing this, but they're not. They knew they weren't. So they didn't do consular notification. And we didn't know we were the government, so we did not say, okay, let's notify the Moorish American consulate. So it says here, state and local governments must comply with the consular notification and access obligations because these obligations are embodied in treaties that are the law of the United States under the supremacy clause of the United States Constitution. And we know, we just read the supremacy clause, but let's look at it again. The several states do not trump or supersede the supreme law of the land. Here it is, this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Every state means if I'm talking to someone from Nigeria, that's two states talking. That's two estates talking. That's two heirs to the estates talking. And anything that happens between us, the Constitution still kicks in. Except we're not under the Constitution, okay? We're not under it. We're aligned with it. Because there is a United States Corporation Company Constitution that is fraud, okay? And then there is the organic Constitution, which is not fraud. That one was written by our ancestors. Yes, we're aligned with that. Okay? So, again, they have always known this document that we're reading from is published by the state, quote-unquote, state of Texas, and the one doing business as Attorney General there. So they have known about consular relations. They know about all of that. But they were not going to say a word until we stood up and invoked the power of the state, which is us, and got in and started looking at these international laws and consular relations and quoting the law and being in our proper status and terminating those corporate contracts and getting those corporations in alignment by leaning them. Okay? So the supremacy clause, there it is. Terminate all corporate contracts, there that is. Okay. I want to call your attention also, and please excuse the noise in the background. So I want to call your attention to, in this document, let me go back to it here. I want to call your attention to, it says here, it says, the question is, and this is from their Q&A in this document, what if the foreign national has an attorney? Now, we're about to see how attorneys don't have anything to do with or say when it comes to international law. The answer is, even though the foreign national may have an attorney, procedures for consular notification still must be followed, especially when the foreign national is a quote-unquote citizen of a mandatory notification country. So attorneys are mute at international law. They don't have any say over that. If the state has agreements, the state, the empire state, if we have an agreement with one of the nations that we're going to notify you every time we pick up one of your nationals, we're going to notify you. Then that national having a contract with an attorney, and that's why you saw a lot, as we became more competent, you saw attorneys running for the hills and saying, I'm not getting involved in that. I'm off of that one because that's one of the Moors. Okay? That's why you saw attorneys heading for the hills. As we became more competent and we started putting those documents out there in red and all lowercase letters, and they started saying, I'm not doing that. Nope. Because international law trumps anything done by anyone doing business as a state according to the supremacy clause of the Constitution. So they were getting in alignment with the Constitution anyway. So I want to call your attention to a couple of other places in this one, and then we will move to the United Nations Convention on Jurisdictional Immunities of States and their property. This one you'll find interesting because it talks about the states and property rights, and which is something we've all been looking at with regard to domiciles and conveyances and all of that. And we're going to show you in their documentation where we had to come together and decide and do the things necessary to proclaim that we are a sovereign state, which we have done competently on the public record. A sovereign state is not dependent on anything foreign for what they're doing. That is why it's 100% important for us to lien all corporations and then put those corporations in their proper status. Okay, that's why that's so important, is because according to international law, we cannot be dependent on anything or anyone foreign to exercise our rights and be who we are. Let me go back a couple of bits. Okay. So here, this is the part of this document where they're saying these are some statements, suggested statements to be made to foreign nationals who are arrested or detained. Okay. And again, when we talk about statements to be made, this is written from the perspective of get jurisdiction and let them know you have jurisdiction. Let them know you have it regardless. Now, when it comes to us and those on our land and things being done and crimes being committed or whatever, and then we are arresting foreign nationals on our land, we automatically have supreme jurisdiction. And then from there, we let the due process take place is what I'm trying to say, okay? But we have sovereign supreme jurisdiction on our land. And the United States Corporation Company gave us a really good example of that, because no matter what was going on, they took jurisdiction over anyone who did not know who they were. So statement 1 is a statement that they're saying that, you know, the United States Corporation Company should be saying to people who are dealing in consular notification in order to set up and establish consular notification. So let's say a foreign national from another place, let's say Bosnia, Herzegovina, was arrested. Then those who arrested the Bosnian national, the foreign national, would say, as a non-U.S. citizen who is being arrested or detained, you are entitled to have us notify your country's consular representatives here in the United States. A consular official from your country may be able to help you obtain legal counsel and may contact your family and visit you in detention, among other things. If you want us to notify your country's consular officials, you can request this notification now or at any time in the future. After your consular officials are notified, they may call or visit you. Do you want us to notify your country's consular officials? Please circle yes or no. Okay. So then, you know, if you want to consent to their jurisdiction, you would circle yes or no, you know, because we know that if you write on their paper or you agree to do whatever it is that they're suggesting, that's agreeing to be under their jurisdiction. Okay? So what are they saying here? They're saying, as a non-U.S. citizen who is being arrested or detained, they're telling you right there that, yes, we have jurisdiction to arrest or detain you. Well, that actually is an example for us to follow as we continue governing on our land, is anyone that comes into our court as we continue to establish consular relations with other nations and foreign nationals on the land or other states on our land, we automatically have sovereign jurisdiction in all matters. We stated that on the public record. You can go back out onto like the Jurisdictional channel at YouTube and look at some of the court actions where we state, you know, we are the sovereign jurisdiction in all matters for our land. And so when a foreign national is arrested or detained, we have the authority to do that on our land no matter where they're from. Okay? Then it says you are entitled to have us notify your country's consular representatives here in the United States. So they're automatically putting you in the United States, which we know we're not in the United States. We are at ancient Morocco. So when we're looking at these types of study materials, because we have not yet written our own, we have to make those distinctions. And then we're, of course, going to put these things in red and all lowercase letters, put it on the public record so that we know how to go about doing what we need to do. And then we'll take out words that, you know, indicate anything other than our national sovereign status. Okay? If you go back and look at the 1906 Citizenship and Expatriation Act, we didn't even have citizens at Morocco. There was only the Moors and subjects. So that Expatriation Act and there's some letters, there was a letter that was written with regard to that act that says that at Morocco there was no laws that treat to citizenship. because we didn't have any citizens here. There were only Moors and their subjects. Everyone else who was here was a subject. 1906, Citizenship and Expatriation Act. And also there's a 1952 or 1954 Citizenship and Expatriation Act that says the same thing. If foreign citizenship cannot be determined, you are a Moorish subject ipso jure. And by then, you know, you could be a foreign citizen someplace else, but here everyone is subject to the Moors, period. And that's actually still the case. Still the case here. And that's what all rise and stand and remain standing is all about, is saying we already know that everyone is subject to us, period. Okay? So, let me see in the chat. I'm looking in the chat. Yeah, let's see. We are more because of the more subject. We are still under this. I'm reading this that's in the chat. It says they are proceeding, assuming we are more subjects because of the more subjects. We're still under their jurisdiction. Some may have had that thinking. Some may have thought that. They are our subjects. And the sooner we go ahead and competently, peacefully put them in that status, they will do as commanded. And we've been saying that for years now. And we've proven that when we are competent, they will yield. When we're competent, they will get in subject status and do exactly as commanded. They've proven that. We've proven it, and they've proven it. We would not be sitting here if that were not true. So, but we must be competent. Some think that, oh, you know, we can govern the way we want to govern, and you know, all that, and that's true to a degree. But there's a certain level of competence that comes with it that must be there, or else, you know, the results will not be what we want them to be. We taught everybody else, and now they're looking at us like, okay, here's your stuff back. Here, Morris, here's the estate, and here's how you govern it competently. Because we don't, as we know, we don't get the estate by being incompetent. Incompetent heirs are minors. We just proved that. They've already been putting that out. That if you're incompetent or a minor, then you go into guardianship, which turned out to be wardship. Okay? And again, they're just putting in these statements, and again, we're going to be doing the same thing. If this statement was something, yes, Empress Charlie, that's true. She says she believes they moved forward because we did not establish we were not subjects. At one point, that was true. That was true. How do we properly establish that we are not subjects? We talked about this even when I did the POW demonstration in February. They could not have even taken me had I told them all rise and stand and remain standing. If I had said that on the spot, they couldn't have taken me. How do I know that? Because when I got in there, they could not even come into the cell. They couldn't even come in because I said all rise and stand. This is and spoke to them as the court. And meanwhile, I'll tell you this, they had their little fake corporate court thing going on with their corpse over there because they had to do something with that corpse. Why? They had to do something with that corpse because even though I had done court actions on the corpse, I had not replaced it with monochrome subject status utility. And what does that look like? It looks just like, something in black ink and capital letters, but black means pale, so that's not what that is. It's a monochrome transmitting utility. But I had to first do away with the black dead utility, the debtor utility, debtor transmitting utility. I had to do away with that, which was done in January, and they were like, okay, let's test her one more time and let her know that, okay, we'll take the debt, but she's going to have to put something in its place because nature abhors a vacuum. We can't, it's not enough for us to say, and we've been saying this for years, we can't keep pointing to them and saying, you're a fake court, you're a fake court, you're a fake court. We know they're a fake court. They know they're a fake court. They know they're inferior when the real court stands. So we had to show them, okay, this is the real court. You're the fake one. We have to do that with everything from start to finish. We have to replace everything unlawful with that which is lawful. So I want to go now to I want to turn our attention to the next document that we're going to just take a few minutes to look at. This next document, I really like this next document a lot. Even though it does need to be rewritten, it needs to be put in red and all lowercase letters because it's got some trick language in it. So I want to show you the trick language because recently I heard some more using the trick language, and I'm like, be careful, because if you go in there talking that, they're going to get you. They'll get you, okay? So let me pull this document up. This document is called the United Nations Convention on Jurisdictional Immunities of States and Their Property. Now that we have properly and competently declared statehood without the United States, we terminated all corporate contracts with them, and we're not going to make any new ones with them. They're in subject status. Okay. Those who were doing corporate duties, we sent the corpse on to Guantanamo Bay and decapitated it, removed that from office, and now we got some subjects there. So I want to bring your attention to this document because it's so important. I heard it quoted in something that I was watching recently. This document is about, statehood and what happens and how states are to treat one another. So let's just talk about briefly the introduction here, the scope of the present convention. They're just saying this is what this convention addresses. This is what it does not address. Okay. Let's see. Yes, just this Geo said to enter the link in the chat. I shall do that as soon as I can. Here, I will do that. I will enter the link in the chat. And I'm actually just going to have to go out there and Google where I got it from. And put the link in the chat. I got it from this one, treaties.un.org. And it is, boy, they turned this whole thing into blue. And here's a certified true copy. United Nations Convention on Jurisdictional immunities of states and their property. It should be a 66-page document. Oh, this one is a lot longer than the one I have. Oh, I see why. Convention on Jurisdictional Immunities of States and their property. Okay, I'll put this one in the chat, but there was one that's shorter than this one. It's a 66-page document, the English version only. Let's see. Here's the one from the United Nations. It's in the chat. I'm going to see if I can find the one that I have here, because that's the true copy. Okay. That's a good question. In the chat, it says, since we are not listed in the Consular Notification Access, how would they go by notifying our consular? We are going to be absolutely proactive so that they don't have to worry about that. Again, when we put our documents on the public record competently, in red and all lowercase letters, we are automatically letting them know competently so that they don't have to notify anyone. All they have to do is do what public servants do, which is check the public record. Now, all Moors are encouraged, strongly encouraged, to just go ahead and whatever territory you're in, lean the policy enforcers in that territory, lean the sheriff, lean the governor, those doing business as governor, those doing business as all of that. Lean the state courts, especially those quote-unquote municipal courts and all of that. Let me finish what I'm saying, and then I'll go to that too, without getting too far off of our subject matter. Be proactive and put the proper notification on the public record. And I'll say this more, don't wait until something happens to try and get this stuff out there. Do it now proactively. Because if there's one thing that I have seen with the Moors, that if I could wave a magic wand and update, I would update it so that every Moor who hears this gets on the notification process right away, long before anything happens. Long before. Because I will tell you that in the last 30 days, I have had more calls from Moors who have been around this that we've been doing. They've been around for years. Some of them have been Moors longer. They've known who they are longer than we have. And they've been watching from the sidelines, just watching and listening and enjoying and, you know, but not doing the paperwork and not putting anybody on notice and not going ahead and doing their court action. Okay? Do it now. Be proactive and do it now. Okay? The notification process is name change, judicial proclamation, termination of corporate contracts, a lien on the straw, a lien on the social, and all of that done by court action, and a fiduciary document, and a proclamation of trust. We have been putting those 6 things up on the public record, and we've been stating, Moors, go ahead and get that out there now in red and all lowercase letters, please. And then, once you do that, start leaning all of those that are claiming some authority in your territory. Start leaning them by sovereign Article 3 court action on the public record. Please do that right away. There's no shortage of the ones you can lean out there. State sheriffs, state policy enforcers, state court, municipal, district, anyone doing business is court, okay? Because, see, it's not that we're not listed as consular notification. We are the supreme law and supreme consular court. We're the only Article 3 courts on the land. And when I say we, I mean all Moors are the only Article 3 courts on the land. So ideally, and this is what I would say ideally, if I could wave another magic wand and have things be ideal and perfect, where I would just say, you know what, it's just perfect, which is perfect already. But all Moors would have all those documents on the public record. They would have leaned everybody in the territory. And if they are approached by policy enforcers, they would automatically start doing court actions. I don't care if they're saying, it's a beautiful day, isn't it? That's a question. He probably saw somebody jaywalking and think it's you and trying to identify. Court action, court action. And some would say, well, that's just not nice. It is not. Nice means stupid. Court actions. Court actions on the phone, court actions when you're looking at them, court actions all day, every day. And then give commands in those court actions. And then tell them. They'll be sentenced to taking a constitutional law class and 2 weeks in jail. This is not something that we have not done. We've done it, and we saved ourselves with that. So if I could wave a magic wand, all Moors will have all of that done. And they will be practicing court actions throughout the day. Practicing court actions throughout the day. When I first started doing that, I was thinking to myself, if I'm doing court actions all day, when do I get to just give somebody a hug and say, hey, how you doing? Long time no see. And the ancestor said, when you see other Moors. I said, okay, that'll work for me. That will work for me. When you see other Moors who know who they are, then you don't have to do a court action on them. You just do it on, make sure that you have dominion over everything in your territory. Now, this document, let's see, this is not necessarily the one I wanted to look at. I'm going to see if I can go back and get the shorter one that I have. Let's see if we can get the shorter one. Okay. It's found in a lot of different places, that's for sure. Let's see. Yeah, this is it right here. Let's see that one. Okay. Just one moment. Let's see if we can get it. Okay, I'm going to have to. Okay. Let's see. Okay. We have one here. Okay, we'll show you this one. This is the good one right here. A good copy of this document. Okay. United Nations Convention on Jurisdictional Immunities of States and their property. So let's take a look really quickly at Article 2, use of terms, and this is key for us. Generally, when the United Nations writes a document, they mind their capitalism very closely. They watch it very closely, okay? But they're always, again, still talking at least in subject status or citizen status or corporate status, okay? Because, again, they're a corporation, too. They could not be the sovereign. So it says here, court means any organ of a state, however named, entitled to exercise judicial functions. When we say that all boards are the court, that's another way of, that's what this is saying about them, okay? But when we say all Moors are the court, they got this precept from us saying all Moors are the court, because all Moors are entitled to exercise judicial functions at any time. And then they talk about what state means, the state and its various organs of government. And again, we are the state. We are the state. We are the Empire State of Morocco. That is established on the public record. Okay? And then they have a lot of different other meanings for that. They say representatives of the state acting in that capacity. Well, agencies or instrumentalities of the state or other entities to the extent that they are entitled to perform and are actually performing acts in the exercise of sovereign authority of the state. We are a sovereign state on the public record. Okay? Our documents that we send out, for example, the fiduciary document, that is a sovereign document that has performance abilities. those documents are as valid as if we walked up and stated the things that's in the document and began doing those responsibilities. Commercial transaction, they talk about that. Any commercial contract or transaction for the sale of goods or supply of services. The state can do those things, okay? And then I want to call your attention right here to where it says State B2. Constituent units of a federal, state, or political subdivisions of the state which are entitled to perform acts in the exercise of sovereign authority and are acting in that capacity. Political subdivisions, I just want to point out that, you know, people talk about body politic all the time. And we are a body politic, yes, we are. But we're also the law, the government, the state. We are all of that. Okay, so when they talk about political subdivisions, the body politic is secondary or third or fourth when it comes to sovereign authority on the land. That's not even first. First authority on the land is our court. According to international law, our courts are first in all things. And when they're talking about immunities and states and things like that, commerce is included in that. That's why our courts have to speak at all times when it comes to commerce. And then they're talking about contracts and all that. Now, I want to call your attention to the trick bag language, because we talked about this a little earlier, and I mentioned to you that that we have to be careful when we are talking about, let's see, where is part 2? I want to go back to part 2. When we're talking about this document and immunities, because immunity is not a term that we use per se. And the reason I say that we don't really use that has everything to do with, let's go here to the state immunity portion of this convention to prove that. Here at Article 5, it says, a state enjoys immunity in respect of itself and its property from the jurisdiction of the courts of another state subject to the provisions of the present convention. Let's look at the modalities before I bring out even more about why that term immunity is not a term that we use generally. It says, a state shall give effect to state immunity under Article 5 by refraining from exercising jurisdiction in a proceeding before its courts against another state, and to that end shall ensure that its courts determine on their own initiative that the immunity of that other state under Article 5 is respected. The reason we don't use the term immunity is the same reason why we are careful and I've not used it, the term exempt. Immune and exempt, those words are basically the same. What those words indicate is that at some point there's someone that we're not immune from or exempt from. Well, no one has the authority to grant us exemption or non-exemption. No one has the authority to do that. That is something that we determine. Okay? It says here, a proceeding before a court of a state shall be considered to have been instituted against another state if that other state is named as a party to that proceeding or is not named as a party to the proceeding, but the proceeding in effect seeks to affect the property, rights, interests, or activities of that other state. That includes our subjects. So if there's something going on with someone who is a subject of our state, yes, Empress Chitali put that, she nailed it. Exemption is under their jurisdiction. That means if they can say you're exempt, they can turn around the next day and say, oh no, you're not exempt, like they're doing the 501c3. Well, immunity is the same thing. If I say, well, we have diplomatic immunity from them, who granted the immunity from them? Who granted that? Who said that? Okay? If they are saying it, right. If they are saying we have granted immunity to the Moors from our jurisdiction, they can turn around the next day and say, oh, Moors, we made a mistake. We meant those Moors, not these Moors. So we grant ourselves immunity. Others don't do that for us. Just like others don't have the authority to record our documents properly on the public record. We have to do that. Immunity is a contract. It's a contract. And so is exemption. Exemption says, I'm under you, but I just don't have to pay today. That doesn't apply to me today. Immunity is the same thing. I'm under you, but I don't have to deal with that today because you said I'm immune. And if we consent or agree to immunity. Now, the Moors, we grant others immunity. Yes, it's a contract. Immunity is something that you actually have to agree to and sign something saying I'm immune. We grant ourselves immunity from all of that. We've done that. We didn't have we had to. We had to grant ourselves, we had to put ourselves on the do not detain list. We had to put ourselves on the immunity from state courts and corporate courts list. We did that. No one else could do it, and they weren't going to do it either. We have to do that. So that word immunity is a little bit tricky. So we don't use it. We just say we have sovereign jurisdiction over all matters on our land. Now, how immune is that? That's the most immune you can be. Now, I like this document because this document is telling us everything that we've been saying. It's affirming what we've been saying about contracts and terminating all corporate contracts and speaking the right language and saying the right things and having our documents write what they need to write and using the conveyance method of statehood to put forth all that we need to put forth. Because Moors in the past have been trying to do things individually while they were waiting for the rest of us to wake up, and I honor them. Now that there's enough of us awake and we have put statehood on the public record, and there are others who put their statehood on the public record, that is how all property is claimed. It's written in the laws for statehood and in the characteristics of a state that states claim things and exert jurisdiction by way of their statehood. Article 7 says, a state cannot invoke immunity from jurisdiction in a proceeding before a court of another state with regard to a matter or case if it has expressly consented to the exercise of jurisdiction by the court with regard to the matter or case, A, by international agreement, B, in a written contract. That's why we terminate all contracts, all corporate contracts, and C, by a declaration before the court or by a written communication in a specific proceeding. That is why we do not go to corporate state court. Because by international law, we are consenting to their jurisdiction by even making a declaration before them. And again, we're talking about statehood here. So, for example, if I were to have some issue going on, a ticket or something, let's just say a ticket, and we're going to be showing you some demonstrations and things, then what would I do? It wouldn't be like Tajiri Bay, and it wouldn't be Pauline Denise Ritchie and capitis diminutio nolo, et cetera, et cetera. That is who I am. However, I would be invoking the sovereignty of the state in order to quash and do away with all of that. Some other quote-unquote state trying to exercise jurisdiction over this state, because each one of us is the estate. We are the state. And that's how they've been doing it. They've been invoking their ship of state and boarding us onto their state and then enslaving, getting us to consent to citizenship, which is their quote-unquote United States Corporation Company. So they've been using the principle of the concept of statehood, even though they're not a real state. And we couldn't just say, you're a fake state. We had to show them who the real state is. Yes, Justice Malik, acts of state and the acts of state doctrine. But for us, it's not an act. It's the laws for state. That's how all of this is done. Again, they're stating right here on the screen, by a declaration. Okay? By a declaration. In other words, you can't invoke immunity from jurisdiction if you're doing these things. If there's some international agreement in a place, if there's a written contract, or by declaration before the court, or by a written communication in a specific proceeding. This is key. And that's why we've been saying don't go to their courts. Don't talk to them. Use the court action language. Use Article 3 court action language. Because see, any declaration that you make to them, they always have said it, and anything you say can and will be used against you in a court of law. Well, if you're doing a court action, then you're the court of law, and you're the court of equity. And then you've invoked jurisdiction properly. There's your immunity. You are the one who states that you're immune by what you do, by your competence. Okay? And I'll tell you this, a written contract can be anything. It can be a light bill. It can be agreement to, I'll just pay this ticket with the fiat. A written contract is also fiat. Now, I know that it is what it is, okay? It is what it is. A written contract is fiat. Because it has an autograph on it, and there's an agreement attached to that autograph, or the signature rather. There's a signature on all fiat. It's in black ink, dead ink. It's in dead ink, and it has a capital letter at the beginning. That is an agreement. That is a written contract. The contract is the Federal Reserve Act of 1913, attached to each and every little piece of fiat. Until we give it a proper name and take all of the other away, okay, we lean everything in sight when it comes to corpses and corporations and dead ink, okay, and then put something in its place, more sovereign delarium. And that something must be competent. It has to be in red and all lowercase letters. It has to have that sovereign autograph on it in red and all lowercase letters, and the seal of your state, which is your right red thumbprint. That means your state is issuing credit to you. And I would encourage you to go ahead and emboss your mors savandalarium with your state seal, your government seal, your consulate seal, whichever seal you prefer. Go ahead and emboss it as well. By the way, the difference between engraving and embossing is a key on why we use embossing instead of engraving. Engraving is, it takes it down into the lower region. So it is, engraving is like putting it in the grave. Whereas embossing is a raised seal. It is elevating the document. That's why we emboss instead of engrave. Islam. And that is etymologically, we're the boss anyway. And the boss is a raised or elevated position, Islam. So they're saying here it's by what you say, it's by the contracts, and it's by international agreement. Okay, that jurisdiction and immunity are invoked or not. That is why we say don't go into their venues, because a declaration before their quote-unquote court, we don't even need to do that. We just need to do court actions on them, because that's outside of their jurisdiction anyway. It says here, Article 8, and then we're going to bring this part of it. Yes, engraved in the exchequer's chamber. Yes, Justice Gilmore, that's correct. Article 8, effective participating in a proceeding before a court. It says here, a state, and this is important, a state cannot invoke immunity from jurisdiction in a proceeding before a court of another state if it has itself instituted the proceeding. What are they saying? They're saying that, for example, if they have detained a Moor, and then that Moor says, you don't have jurisdiction over me, you don't have jurisdiction, and they invoke jurisdiction, and they're saying this Moor is saying, you don't have jurisdiction over me, I'm a Moor. But then the Moor turns around and elevates, quote unquote, the case to their higher corporate court and sues them for some $5 million or something like that in their court, and saying, oh, I raised that to the Supreme Court, and I'm suing you because you have breached my rights. What are they going to do with that case of the $5 million that you're saying you elevated it and it's out of their court, and you're going to sue them? They're going to dismiss it and remand it back down to the lower court, which is not lower. They're all low. They're all the same. They're all courts. It's right here in how they've been doing business. If you're trying to turn around and sue them in their court for something that they did, then they're saying you are agreeing to their jurisdiction, so they can go back and get you for old and new. No, don't do it. This is why we do not file lawsuits in their courts. That's why we don't do it. They don't have anything to pay with anyway. And then this next part is very important too. It says a state cannot invoke immunity from jurisdiction in a proceeding before a court of another state if it has intervened in the proceeding or taken any other step relating to the merits. What does intervening look like? Intervening is when any of us If someone has something going on in a state court, instead of invoking jurisdiction, we go in and try to argue with them. That's intervening. It's incompetent. We don't do it. We just go ahead and do a court action and invoke our own Article 3 jurisdiction over the matter, the subject matter. Jurisdiction over personam jurisdiction. Okay, over any matters, territorial or subject. We invoke the jurisdiction of our state. It says, however, if the state satisfies the court that it could not have acquired knowledge of facts on which a claim to immunity can be based until after it took such a step, it can claim immunity based on those facts, provided it does so at the earliest possible moment. A state shall not be considered to have consented to the exercise of jurisdiction by a court of another state if it intervenes in a proceeding or takes any other step for the sole purpose of invoking immunity or asserting a right or interest in property at issue in the proceeding. That's a trick bag, because if you're asserting a right in their court, then you're agreeing to their jurisdiction. Jurisdiction has to be, the law, in order for the law to be properly executed, it must first be established. How do you establish the law? Proper identification of the parties. Well, when you properly identify the parties, you're going to be identifying any property associated with those parties. Now, from one state to another, state of equal status, then you can assert a right or interest in property. But that has to be done at the beginning of the proceeding as to why you're doing that, why you're invoking jurisdiction where the property is concerned. Because property can be a subject. A living, breathing subject can be property. Number 3, the appearance of a representative of a state before a court of another state as a witness shall not be interpreted as consent by the former state to the exercise of jurisdiction by the court. So consuls can invoke jurisdiction, okay? And we do special appearances, and our documents speak. And no one represents the Moors. We just speak on behalf of the state or in support of and in assistance of our state. Failure on the part of a state to enter an appearance in a proceeding before a court of another state shall not be interpreted as consent by the former state to the exercise of jurisdiction by the court. Failure on the part of a state to enter an appearance. So if a state court or a corporate court or an inferior court specifically says something and we're the state, if we don't respond to that, if we don't, and I don't say respond, but if we don't make an appearance in that matter, that's not, silence is not acquiescence when you're the state. Let me put it that way. And we wouldn't remain silent in that case anyway. We would still speak, but we would invoke our sovereign status and state that they are subjects on our land. Now, when we, again, and we'll stop here for the evening because there's so much more in this document. But I want, the one thing I want to make clear is that we need to be sure that we don't use the word immunity for us, for the Moors, that we invoke sovereign jurisdiction in all matters. Okay? Immunity comes in when our sovereign state and another Moorish sovereign state have something going on, or there's something that needs to be worked out in the court. And that's where immunity comes in at, is when you're talking courts of equal status and standing. Article 3 court. Okay, that's between us and other Moorish courts, not subject courts and inferior courts. Inferior courts and subject courts have no say in terms of jurisdiction when it comes to the Article 3 court, because we work out our own issues. Okay. With that being said, we are at the 2-hour mark. Thank you for attending, and I will say that we're not going to have these calls for the next 2 weeks until the 24th, which is a Wednesday. We'll have our regular call on Wednesday the 24th, and we'll make the announcement beforehand. If you don't see the announcement, then we will. That means that we're probably either going to be going live on YouTube, or we will announce something as in its place. Okay, so we won't just leave it out there. We'll announce something in its place. Islam, peace and grand rising to the sovereign, original, indigenous, natural, divine heirs. Islam.